Good morning, everybody, and welcome to our latest COVID-19 webinar. I can see a few people are still joining us as I'm speaking, so we'll just give everybody just 30 seconds or so to log on and to be with us for this morning. Yeah, I can still lots of people logging on right now, so we'll hold off starting this morning's proceedings just for a while longer, so just bear with me. We'll still, though, have everything wrapped up this morning by 11:30 to allow you to carry on with the rest of your day. So if you just bear with us whilst we get everybody online. Okay, that's great. That looks like everybody's now online that should be. So welcome to this morning's webinar, COVID-19. It's our second webinar around COVID-19. Our first one was, of course, around everything you need to know as the pandemic broke out and everything about furloughing and contract matters around force majeure and business interruption insurance. This webinar, though, is very much focused on everything you need to know about getting back into work and back into business. This morning's speakers, we have Michael Stokes, who's head of our employment law, and he is going to be talking around the latest around furlough and then how to manage your staff getting back into the offices and factories. And then Kamal Charan, a partner in our regulatory team who leads our health and safety work, he's going to talk to you about everything you need to bear in mind to get your staff back in the workplace and all the practical steps that you should be taking. And then finally Dan de Sauls is joining us again this morning. His focus this time isn't going to be around force majeure, it's going to be contract variations and terminations and the things you should be doing around your contracts as you start to get back to business. Thank you to those of you who've already given us questions ahead of the webinar this morning. Please keep the webinar questions coming in. I can see those on the portal. For those of you that have been at events that I've chaired in the past, you'll know I normally like an interactive event and like to take questions from the floor. But unfortunately today, the nature of this event, we're going to take all the Q&A at the end. But do please keep the questions coming. Last time we had lots of questions and we answered most of them. What we'll commit to do again today is if there's questions that we can't get to answer, then we'll answer them directly to you afterwards. And again, what we'll do is we'll release copies of all the slides and answers to all the questions that we've dealt with and the ancillary questions further in the next few days. So without anything further to add from me, I'll hand over to Michael Stokes, who's head of our employment law, and he's going to give you an overview of furloughing and then how to bring your staff back to the workplace. So Michael, over to you.
Thank you very much, Robert. As Robert says, Michael Stokes, Head of Employment. I'm going to talk fairly briefly about furlough. You'll have done a lot of work on furlough. You'll have probably claimed furlough grant already, and so you'll be experts already. But the reason I'm going to touch on it for a little while is just so that we know where we are, how we got where we are, and how that might affect what's going to happen next, because the real theme of today's webinar is the return to work. And of course, we're right at the corner. We're right at the corner here because we've been locked down almost completely for a couple of months. And now we're just looking at how we're going to come out, and employers ought to be thinking very hard about exactly how they achieve that safely and in a financially positive way, of course. Now, I should say a few things. I'm almost always going to refer to employers and employees. That's my default setting. I haven't forgotten other organisations who are involved, other types of worker, self-employed people to some extent, IR35 directors, all those people who are in some way in the furlough scheme. I haven't forgotten them. But I'm going to probably refer to employers and employees just because it's easier for me to do that. I also haven't forgotten that there are some organisations, public sector organisations, where furloughing staff is in fact going to be, won't have happened in all probability. They've got a completely different problem. So I'm not ignoring them either. I'm just dealing with the people who have had to deal with furlough and how they might deal with what's coming next. So what's happened so far? Just over 2 months ago, no one had a clue what furlough was. Most people wouldn't have heard the word. I knew that word from American war films. It was when American soldiers took leave. Otherwise, no idea what it meant. And when employers particularly ask us, well, what is furlough? What is that meant to mean? No one knows. No one knew until these guidance documents, Treasury direction and so on came in. It is an entirely new concept. Effectively, what's happened over the last couple of months is a massive state-funded layoff arrangement that's familiar to me as an old employment lawyer. Layoff arrangements when a business wasn't doing very well are terribly familiar from the past. If some engineering company in the Black Country needed to save a bit of money and send some employees home, they would have a ready-made layoff agreement under which they could do that. Those rather went out of fashion over the last 20, 30 years. So what had to happen if the whole economy wasn't going to crash a couple of months ago was for the government to underwrite that sort of layoff arrangement. And in fairness, it's a fairly generous layoff arrangement if you look at it in those terms, and I do, because that's the angle from which I approach this whole issue. Employees and employers cooperated to a very large extent when furlough became a thing, so that although we had a huge number of queries and difficult questions to deal with about furlough in the first few days, all that was going on, strictly speaking at that time, was to make sure that employers were lawfully sending people home, often for less pay. So it was all about not breaching the contracts of employment. In some cases, thinking about whether employees had to be dismissed and offered re-engagement, but that in fact didn't happen in any of the cases I dealt with. And that of course is because when this first cropped up, when this first happened only 2 months ago, employees and employers were all heading to the door at the same speed. They were racing each other to get out of the workplace because the employees didn't want to catch anything from their employer and vice versa. So I think it's fair to say that although it was a great trauma as far as employers were concerned, last time round, over the last 8 weeks or so, there's been a huge amount of cooperation between employees and employers to make that state-funded layoff arrangement work, because everyone wanted to get out of the workplace. So effectively it was fueled by fear and money, and that was a neat combination which worked a treat. Why was it so difficult? Because we had a huge number of queries, everyone asking what's furlough, what does it mean? Can you be on holiday and on furlough at the same time? Can you be on sick leave and be on furlough at the same time? And why was that so difficult for employers, employment lawyers to answer? That's because no one knew, because furlough was just plucked out of the thesaurus effectively by a civil servant in Whitehall as a word that wasn't the same as the words that had gone before, because this was going to be a new thing. And then the rules gradually came in, the guidance came in from the government, 2 or 3, even 4 iterations of that. And then of course the Treasury direction, ACAS guidance, everyone had a go. Every barrister's chamber specialising in employment law, they all piled in to say what the law was in relation to furlough. But effectively all of us were doing something that was like trying to learn a foreign language from the ingredients list on the side of a packet of cornflakes. There was so little information available that you couldn't say what the important legal principles were. Furlough was also difficult because it was only ever meant to be a grant. It's not employment law at all. It's a means of getting money from the government if you follow certain rules and if you meet certain criteria. So it's not employment law in any way. But of course it touches on employment law because it refers to certain states of employment, states of situations during someone's employment. So like being on sick leave, like being on holiday, working, not working, providing services, providing valuable services, volunteering. Those things are all very familiar to employment lawyers, but how they worked in conjunction with furlough, that was all a bit of a mystery and has only gradually become clearer. The first wave, as I say, of queries was all about how to get people out of the building effectively. So that was comparatively straightforward, although administratively very difficult for employers. But from an employment law point of view, that was comparatively old school law and therefore straightforward. Where the problems really started, I think, other than the number of times the government had to update the guidance, inevitably, no criticism meant there, very difficult situation to find themselves in. But where the problems came in was when old, difficult employment law issues that had never been litigated properly, never sorted out, all crashed into this new situation. And the classic one is about holiday, leave and holiday during furlough. What if you'd already booked a holiday? How on earth do you deal with bank holidays, effectively agreed holidays in advance? Can people cancel their holidays? And crucially, can employers make employees take a holiday? Now, I was talking to employers at the beginning of all this, seems so long ago, it's only a few weeks ago, when employers didn't even know that there was a mechanism by which they could give notice to their employees to take holiday. They didn't even know they could do it. And that's because holiday was always dealt with on a voluntary basis. It was always negotiated effectively by employers and employees. So it was never an issue. Once everyone was reminded that there is a right in the working time regulations for employers to make employees take holiday for their own good as a health and safety measure, mind, that's what it's for. Once that became clear to everyone, then the question was, well, can you actually take a holiday like that during furlough? What is furlough anyway? But can an employer make an employee take holiday during furlough when they're locked up in their one-bedroom flat with a dog and 5 children? Is that a holiday? And of course, the underemployed barristers dealing in employment law, no work on, were all giving their ideas about whether that was possible at all in the first place. Even the government finally has published its own separate document about holidays and furlough, and it can't answer that last question. It's not even trying. An important point in all this is that the government always said in its guidance on furlough that it wasn't changing employment law. It was just touching on it. Now, what the government has said is that it's not expressing a view about whether you can make an employee take a holiday. What's coming? More slides. Let's have another slide. Now you're going to be faced with a situation where employees either want to come back desperately or you want to keep them away desperately. And so unlike last time round, employees and employers may be going in different directions, and you may need to, you will need advice. You'll need to think about some of these issues. Some people won't want to come back. They may be caring for someone who's shielding. They may be unwell themselves, or shielding, or vulnerable, as defined in the various sets of evidence. If they're concerned about their health, they may refuse to come back, and Kamal may touch on that later on when he's speaking. Can I have another slide, please? If you want your employees to come back, if you need them back, you're going to have to reassure them. Again, Kamal will look at these issues in health and safety terms in a moment, but just in a basic employment lawyer's way, the workplace has got to be safe. And there's a danger that if an employee has a reasonable belief that their workplace is not safe, then there's a danger that an employer could dismiss an employee in circumstances where they're concerned about their health and safety. Could be an automatic unfair dismissal in that situation. It'd be quite a brave employee to do that, but this is life or death for some employees. We've never had that situation before. We get a few cases about health and safety dismissals along the way, It's not normally about whether you might die if you come into the workplace or cause the death of a family member. So those are big issues that employers have to be quite sensitive about and very grown up about. Some employers I've spoken to, even now, even a few weeks ago, when they were thinking about having people back, was whether they could discipline employees who were refusing to come back. And of course, you mustn't jump in and do that straight away. Dan may talk about GDPR later on. You may have questions about GDPR later on and data gathering, but what you're going to have to do is to gather a lot of information from individual employees to judge whether you can safely have them back and whether it is reasonable for you to ask for them to come back. And that's why the sort of bad news I'm giving you in this webinar, and we can deal with questions about it later on, is that the furlough side of things that I talked about some length before, that was the easy bit, because everyone was pulling in the same direction, government, employers, employees, when that all cropped up. No one was particularly upset at being furloughed. Some were, but most weren't. They were keen to get out of the workplace. Now you're going to have disputes between employers and employees about whether they can, must, should return to work, whether it's safe. And then also, of course, on the next slide, important issues relating to changing terms and conditions, restructuring, redundancies, consultation, and trying to avoid legal action. And all those are going to be largely individual issues that employers are going to have to address, whereas before they were dealing with one issue, which was, can we get our workforce out of the front door? I better stop there. Robert, thank you very much.
So thank you, Michael, for your further thoughts on furlough and then the practical issues to consider when returning employees are coming back to the workplace. I think that leads us neatly on to our next presentation this morning, which is from Kamal Charan, who's a partner in our regulatory team who specialises in health and safety matters. And Kamal is going to walk us through the practical steps on the ground that employers should be taking over the next few days and weeks ahead as people start returning to the workplace. So Kamal, over to you. Thank you.
Many thanks, Robert, and thanks ever so much, Michael. It really does dovetail very nicely into, of course, health and safety, which is one of the hot topics at the moment, of course. So as we know, isolation is being eased and people are returning to the workplace, and the government's requiring businesses and employers to complete specific COVID-19 risk assessments as part of the permission to resume normal service. As always, from a health and safety perspective, from my perspective, the starting point is really to make sure we're still complying with the obligations in Section 2 and Section 3 of the Health and Safety at Work Act. And those obligations are these magic words: all reasonably practicable steps must be taken so as to ensure the health and safety and welfare of your workers and anyone else who's impacted by your operations. So this includes keeping up to date with work-related issues and risks posed by COVID-19, as well as planning and implementing all reasonably practicable risk reduction measures. With regards to Section 2, as you can see on my slide, I've put there, employers have a clear duty to protect the health and safety of their employees whilst at work. This hasn't changed, and of course, Section 3 extends that to non-employees, to visitors and contractors that you may also have on your site. Section 7 is with regards to employees, and Section 7 of the Health and Safety at Work Act says that employees themselves have a duty to take reasonable care of their own health and safety and that of the people that they work with. So this includes cooperating with their employer to enable it to comply with its duties under the health and safety legislation. Employees who refuse to cooperate or who recklessly risk their own health or that of their colleagues, and indeed of their customers, may also be subject to disciplinary measures, as Michael mentioned. By way of reminder, breach of the Health and Safety at Work Act 1974 and the regulations that have been made underneath the Act is a criminal offence enforced either by the Health and Safety Executive, by the local authority, and in certain situations, of course, can be enforced by the police if we're dealing with fatalities, there are corporate manslaughter issues and also gross negligence manslaughter issues to be considered. So really the potential here is for us to ensure that the exposure that we faced by COVID-19 is being really addressed in the documents that we have internally within our businesses, and that the risk that this poses for our businesses is carefully controlled. Now on our next slide, we look at reminding ourselves of the government's checklist. So let's remind ourselves of these 5 points. They first have said, let's work from home if we can. But for those who can't work from home and those whose workplace has not been told to close, staff should go to their usual workplace if it's reasonably safe to do so. Number 2 here, we have maintain 2 meters social distancing wherever possible. Now employers should look at, if they can, redesigning workspaces to maintain their 2 meter distance between people by staggering start times, for example, or looking at creating one-way walkthroughs, opening more entrances and exits, for example, or changing seating layouts in break rooms. Of course, this is easier said than done. Some workplaces are designed to be flexible in this sort of manner, but of course there are other workplaces up and down the country that are very Victorian in nature, and some of these recommendations really can't be implemented. So where people can't be 2 meters apart, let's see if we can manage the transmission of that risk. So employers should look at putting into place barriers in shared spaces, for example, creating workplace shift patterns as mentioned, or fixed teams, minimizing the number of people in contact with one another, or ensuring colleagues are facing away from each other. The other step that the government has helpfully set out is to reinforce cleaning processes. So workplaces, of course, ought to be cleaned anyway, and arguably they should be cleaned more frequently, paying close attention to high contact objects such as door handles, keyboards. Employers should provide hand washing facilities and hand sanitizers at entry and exit points. Now, the final point that I put on my slide there is really the crux of where we're at the moment. So the government's encouraging all businesses to carry out a COVID-19 risk assessment. Now, of course, businesses up and down the country have already been undertaking risk assessments as part of their normal day-to-day operations. So the COVID-19 risk assessment really operates within the current health and safety and employment legislation that you're already adhering to. But if possible, employers should publish the results of a specific COVID-19 risk assessment on your websites if you have 50 or more employees. And the risk assessment should determine the likelihood and consequences of exposure to COVID-19, and the response to that risk assessment should be measured and proportionate to the risks that you've identified. It should be a live document, and it should be reviewed as you advise from the government and its agencies changes. So if we move on to our next slide, I've set out what I think a COVID-19, a C19 risk assessment may wish to contain. Now, a risk assessment covering exposure to COVID-19 will be different from one organisation to another. So healthcare workers, for example, retail, home delivery drivers, utility engineers, construction workers, they'll all have different exposure to risk. So really, before a risk assessment is undertaken, let's ask who's doing what and how, where are they doing it, why are they doing it in that way, and what are they using as their tools in their day-to-day work. The sector guidance you may have seen, which has been published by the government, sets out that employers should be working through a number of steps in order, and there are some key themes that apply to all of these sectors. So, for example, as mentioned, increase the frequency of hand washing and surface cleaning. Can working from home be the first option if it's reasonably practicable to do so? Social distancing guidelines ought to be followed, and if they can't, then look at the transmission of risk and how that can be suppressed. Further mitigating actions, of course, can include keeping the activity time involved as short as possible, using physical barriers, being placed back to back if you are in an office situation. And then we then look at PPE. Now, again, this is a very live topic, and there is a specific, you won't be surprised to hear, a specific piece of legislation covering PPE, which is called the Personal Protective Equipment Work Regulations 1992. Although the key point that I'll make here with regards to the PPE regulations is, of course, in ordinary situations, you would provide PPE to your workers to stop them being injured by the work that they're undertaking. So, for example, if you're working in a metal fabrication workshop, you'll be providing employees with gauntlets or gloves to help stop any cuts and nasty injuries that would occur from the tools that they'll be using. Here, though, of course, with the COVID situation, there's some discussion as to whether face masks ought to be used, and there's some question mark as to whether they're going to be effective to control the transmission and reduce the transmission of COVID-19. And of course, there's scientific and government guidance which suggests that certain face masks of a certain grade, so medical grade, for example, is the grade that ought to be used if you are going to be using face masks within a workplace. That won't necessarily guarantee the stopping of the transmission of the virus, but it will at least eliminate it to a certain extent, or reduce it to a certain extent, to allow you to undertake work if it can't be undertaken within outside of the 2 metre social distancing. But what I would suggest is, if you are thinking about using face masks or face coverings, consult with your employees first. And also, if you are going to be using such measures, such PPE, make a note of why you're using PPE in the first place, and make a very structured note of what PPE you are using and what it is designed to achieve, what sort of risk mitigation you're likely to achieve from it. As I've mentioned before, there is an onus for those organisations and those employees, if we move on to the next slide, sorry, to publish risk assessments if you have 50 or more employees. And there's, again, little guidance as to what and where this ought to be published. If you have a website, that would be an ideal place to publish at least some information to say that you have undertaken a COVID-19 risk assessment, you have considered the risks that are applicable in your workplaces, and that can be found in a certain part of your website or a hyperlink provided to the risk assessment itself. In doing so, you're going to allay any fears or any concerns that either customers may have if they're coming to your workplaces, if it's that sort of workplace where you have customers and clients attending, and it also seeks to allay any concerns of your staff members and your employees for them to at least understand that you have taken all the precautions that you can. You've really assessed the risks of the pandemic and the virus coming into the workplace, and you've put mitigating measures in place as far as you're able to. Now, moving on to the next slide, of course, the Health and Safety Executive also suggested their position on COVID and how they're going to be enforcing matters. And the HSE has said that it'll undertake spot checks, and indeed they've been given a substantial government budget to do so. So this is really a warning for everyone that this is on the cards. If they feel that a particular industry or a particular workplace is falling below standards, there's likely to be a knock at the door, and health and safety inspectors or local enforcement, environmental health officers coming into your workplaces and looking at what measures you have taken to ensure the mitigation of the pandemic or the virus spreading further within your workplace. So it's kind of I'll use the term of not so veiled threat that the health and safety executive are at starters orders, really. There was a communication from the health and safety executive fairly recently where they did a tour of the UK via digital platforms, where they tried to answer questions and allay concerns of employers. And I asked a question of the chair of the health and safety executive: how would my clients show and demonstrate that they have, so far as reasonably practicable, taken measures to protect their workforce? And the comment back was along these lines: if you have followed the Public Health England guidance, that goes 90, if not 100% of the way to show that you have taken reasonably practicable measures. So that's a really, really good guideline, I think, of ensuring that if you have taken those measures on board, and if you've address them in your risk assessment, that's going to go some way to allaying any concerns that the regulator may have about your workplace or about the way in which you're operating. If we just go on to the next slide, the Health and Safety Executive have also suggested that COVID-19 deaths are what's called RIDDOR, reportable. RIDDOR is a regulation, it's a reporting of injuries and deaths and dangerous occurrences regulations. And it's specifically the Health and Safety Executive has said that as a dangerous occurrence, RIDDOR, COVID-19 is reportable if there's an unintended incident that leads to an exposure at work. And it should be reported as a case of disease if an employee is diagnosed as having COVID-19 and there's evidence that it was caused by exposure at work. With regard to statistics, everyone likes a statistic. And the Health and Safety Executive have said, although these figures are taken with a pinch of salt due to lags in recording, but between March 9th and the 26th of April, so these figures are now almost a month out of date, the HSE received more than 4,000 workplace concerns related to coronavirus. Unsurprisingly, the top three sectors are represented by manufacturing, construction and health. And it'd be interesting to see where those figures are now and going into June and July to see if there's been any differentiation between those sectors. And of course, we've had construction sites reopened, we've had manufacturing sites. I guess some of them haven't actually closed, given that remote working isn't possible for many manufacturing businesses. And of course, the health sector, we've all heard the news and we've all been keeping an eye on the NHS and also the care sector. So it'll be really interesting to see if those percentages change as the pandemic unfolds and as we get some clearer guidance from the government as to how we ought to be reopening our businesses. So in summary, moving on to my penultimate slide, many of you, of course, will be familiar with the classical risk management theory and specifically the hierarchy of control, where you look to eliminate or engineer out risk, and then you work through other risk reduction mechanisms. The most effective control, of course, in terms of the pandemic is elimination, and we've seen that to a certain extent with regards to isolation. But of course, a vaccine is not really within our gift. It's for scientists and those experts to prepare a vaccine that protects us all from the virus. So with elimination being isolation and vaccine, it's really important for us all to consider how we can reduce, innovate, control, and then use PPE if we really need to within our workplaces to ensure that the risk of any virus spreading is minimized. My next point there is to ensure that we're all engaging employees. So I put fact versus perception, and I'll give the example of face masks again, where face masks are very visible and are very practical. If you wear one, of course, you feel as though you have some control against either contracting the virus or at least spreading it yourself. And like I've mentioned, there's some discussion as to how effective they are, but it comes to this point about fact versus perception. And I guess the point is if your employees feel safer wearing a face mask, just bear this in mind when you conduct your risk assessment, that some employees and some people may feel safer wearing some face protection or something that gives them that level of control that they're doing something that's above and beyond government guidance. So here we're just really making sure that we're building confidence so that your colleagues and customers are happy to come back to the workplace. And finally, I've put there account for changes in behaviour. And by that, I really mean amplify the things that have worked well for you as a business and as a sector, and maybe let go of the things that are now not so fit for purpose. Now, of course, people may have become more suspicious or more impressionable as the 8 weeks of lockdown have progressed. Above all, they may well be less willing to engage with anything that seems new or strange. Culturally, organisations should be prepared there for a shift, I think, that isolation may have caused the possibility of reintegration issues. So remote working, for example, will force a push in demand for further remote working. So how can you deal with this as a change in behaviour in your workplace, something to consider as part of your risk assessment, maybe something to consider as part of your business and health and safety policy going forwards. Of course, you've all had to adjust to making decisions quickly and assisting the migration of staff, for example, from work to work from home, working agilely, embracing technology. Therefore, again, amplify the things that really worked for you and make those really clear within your businesses and within the workforce to ensure that people are really comfortable coming back to the workplace and they feel as though risks have been mitigated as far as they can. So my final slide, just my concluding remarks, mitigate against regulatory actions and claims. Health and Safety Executive have warned us that they are on the lookout for those businesses and those industries that haven't been quick off the mark to ensure that they have been seen to protect their workforce. So really lean into these issues and really try to tackle them head on. Of course, ultimate responsibility lies with the business and its directors to ensure that risk has been assessed properly and you have suitable and sufficient risk assessments in place. And of course, finally, help is at hand. If not here at HCR, of course, a number of resources online which you can look to give you that assistance that you need. Robert, back to you.
Thanks, Kamal. That was a great overview there of the health and safety regulatory framework for everybody to be thinking about, and also some really interesting practical tips to work through for everybody when assessing their risk management and how to get their employees back into the workplace. I'm sure there'll be lots of questions for you because there's an awful lot of detail there for people to digest. Do please keep your questions coming. I can see them in the Q&A. A number of you have also emailed us directly on those, so do please keep sending the questions. So over to our final speaker now, Dan de Saules, a solicitor in the commercial team. Last time Dan was talking about force majeure and Covid-19. This time though he's looking more around the issues around what happens with contract terminations and variations as people get back to work and their contractual relationships start to develop. So over to Dan for our last speaker, and then after that then we will have a brief Q&A session which will take us up to 11:30 to get everybody finished on time. So thanks, Dan, over to you.
Thanks, Robert. Hi everyone, my name is Dan de Saules and I'm a solicitor in the commercial team here at Harrison Clark Rickerbys. Today, as Robert said, I'll be providing a brief overview some of the elements to consider if you are to engage in any contractual variations or negotiations with your counterparties. So firstly, what should you be considering? Well, following the recent government announcement, obviously more sectors of the economy will now begin to increase productivity. Manufacturing, construction, logistics and distribution sectors are likely to experience rapid increase in activity, and therefore contractual negotiations are to be pivotal in managing production and supply. Now, for those operating in the hospitality, retail and leisure sectors, well, these businesses aren't envisaged to return to normal until probably August or later. However, equally, these businesses may still need to enter into contractual negotiations to either decrease or postpone production, while switching their focus to restructuring or perhaps reducing costs or finding alternative routes to market. So as we know, modern supply chains are highly integrated and often expand cross-border, and companies have increasingly become reliant on fast, lean, efficient supply chains. So as we begin to exit the pandemic, albeit slowly, we will all be moving towards a new normal, and businesses will therefore have to adjust, reassess and potentially renegotiate a lot of their contracts. So like any contractual negotiation, there has to be a mutual benefit to both parties. One of the key things arising out of COVID-19 is do not be forced into accepting a variation purely because of COVID-19, and don't be bullied by customers who may threaten to terminate contracts or refuse to pay at all if you do not agree to vary certain terms. So assess what you are in control of and how you can then change the current situation. So you should be proactive and open in discussion with the counterparties, but also be aware that if any new deal or variation does not feel right now, it will probably not be the right deal when COVID-19 ends. Next slide, please. So in particular, what sort of provisions should you be looked to varying? Well, the obvious one is obviously change in payments and pricing terms. But saying that, thought should still be given as to whether this is definitely needed. So for example, would it be simpler to offer a one-off discount to customers without varying or changing your traditional pricing terms? So consider your key customers or suppliers, and can you look to offer discounts to these parties, first of all, who have sort of a stronger history of paying on time. But if you are looking to extend traditional credit terms, then always consider whether this is a good idea or if this simply masks a potential deeper payment problem of some of your debtors. Delivery terms, so are these still practical and achievable? Do any lead times need to be extended? And tied in with that, do any relevant service levels need to be relaxed? Can orders be collected for a short interim period? That's another possible option. Forecasting. So usually forecasts are expressed as non-binding. However, these should still be assessed and discussed between the parties so as to provide accuracy on future orders. Similarly, are there any minimum purchase obligations in your contracts? And do these need to be varied so as to avoid potential breaches of contract? So if your business is part of a larger supply chain, volumes will need to be carefully managed to ensure that supplies flow into the supply chain in the appropriate volumes at the right time, as a failure to supply or obtain materials, products or otherwise, can obviously have knock-on effects further up or down the chain, which could ultimately affect your business. So it's worth considering the wider scope of that. And I think as well, apart from the most obvious ones, consider the wider contractual terms. So become familiar with the contract. So what else needs to be varied or could be varied? So are there any interest clauses or termination rights which are linked to non-payment or late payments? Can these be waived? Who bears responsibility for any additional costs of storage for non-delivery, for example, with government lockdowns, etc.? What terms will apply in the event of insolvency? So particularly around payment of goods and potentially passing of title to those goods. And in the worst case scenario, does your contract provide for an exit plan? So these are all sort of the wide elements to consider. Next slide, please. So once you are sort of settled on terms or variations with a counterparty, so how do you go about varying your actual contract? Well, most contracts will contain a variation clause along the lines of no variation shall be effective unless it is in writing and signed by both parties. Now, to comply with this, businesses can and should be focusing on using electronic signatures to execute documents. Equally, businesses should be identifying those contracts or documents which may be limited by electronic signatures. Those examples are documents to be filed at the land registry. But as a general rule, across England and Wales, electronic signatures are legally enforceable. However, documents to be executed by deed, for example, may pose a potential issue, as currently the law does not allow for any remote witnessing of documents where a witness is not physically present when a signatory signs a deed. Saying that, there are other ways for a company to execute a deed electronically without the need for a witness. And there's a relevant section in the Companies Act which provides for the method of execution by two signatures. And there's no actual requirement in that particular section of the Act for those two signatories to be applied the same signatures at the same time. So that's something to consider. But leading on from that, that also raises a point as to who has authority to sign those documents and variations. So usually this will be a director or two directors, as just mentioned. However, thought should definitely be given as to whether those individuals are, for example, available to sign, or indeed whether they have adequate software or hardware to sign and access the document electronically. So as long as a director or a similar person with authority is available to sign a document, there are electronic platforms such as Adobe Sign which can be used, and these are great as they offer further protection to the verification process of signatures. So these platforms will create a digital audit trail. So they will detail who has signed the document along with their email address and IP address. And you can even set a passcode which can be used to authenticate those signatories. And I think this is something definitely to consider when signing your contracts and if the issue of authority is a question. So given the current situation, electronic signatures are by far the easiest and most convenient method of signing variations or new contracts. But just a word of warning, so caution should always be exercised in verifying the signatories to the contracts or variations and checking whether that signatory has the requisite authority to actually bind your counterparty and obviously agree to those variations that you've sort of discussed and worked hard at length to agree. Thanks, Rob. That's a very brief overview for me.
Thank you, Dan. It's very useful for everybody to understand where their contracts sit at the current time and the issues they face around variations and terminations. And almost certainly, as a commercial team, we're starting to see an awful lot of that advice now, very much akin to back where we were in 2008-9. When businesses were looking at their contractual arrangements and how to vary them. So thank you to that, Dan. Thank you to Michael, Kamal and Dan for their presentations this morning. Over to them now for a panel Q&A session. Lots of questions, understandably, around returning to work and difficulties in getting employees to return to work. Michael, perhaps an opening remarks from you, please, if you could. Lots of chatter with clients over the last week or so, how to deal best with difficult, inverted commas, employees or challenging employees who are at best reluctant to return to work and at worst, probably an awful lot worse. What would be your practical advice to those clients that will be facing those conversations over the next few days and weeks ahead?
The main point would be communication, and record keeping, so that if it ever matters, if you ever have a dispute in a tribunal or a court one day, you can show the judge just how reasonable you were being at all stages. It's terribly important for employers to take account of the individual circumstances of the employees, and it's also important, I think, for employers not to assume that someone who's been a bit of a thorn in their side in the past as an employee will be being deliberately difficult in this situation. There might be, but if they assume that, they're going to get into difficulties straight away. So I think employers are going to have to take their time and approach all problems of this kind, and there'll be many, very methodically, approaching them all in the same way and making sure that they're not making knee-jerk decisions based on previous dealings, because everything to do with COVID-19 and returning to work in a pandemic is unlike anything any HR department or HR director has ever dealt with.
Thank you, Michael.
Kamal wants to have a pop at that one as well.
Yeah, I think that's absolutely right, Michael. We're already experiencing lots of clients asking those sorts of questions in expectation of those sorts of discussions. So thank you. Kamal, anything that you would want to add from a health and safety perspective as to the minimum, the guidance, the best support to offer clients at this time?
Yeah, I think echoing Michael's sage comments there with regards to having open dialogue and consultation works both ways from an employer as well as from an employee. So it really is trying to, I guess we're in a position now where we can almost press the reset button within the cultural workings of an organisation, and hopefully we can have more effective and constructive dialogue between the two parties, employer versus employee. So I'd echo Michael's comments there in the sense of try to get around the table if you can and have those constructive discussions and iron out the issues before they become proper legal issues as far as you can, and then see, then I'd see where the land lies once those discussions have taken place. But I think a constructive way forward is probably the best way forward.
Thanks, Kamal. So I think we'd say have the dialogue, have the communications, be reasonable, have no assumptions in those conversations, and then above all else, as lawyers, of course, we're going to say keep notes, because those could be your fail-safe at the end of the day. So thank you to Michael and Kamal for that. Carrying on in a similar theme, but this time from the employee's side, a question from one of our attendees this morning, I don't know who. Can my employer insist upon me coming back to work, even if I'm worried about potentially infecting a member of my family, if I can possibly work from home? You can hear that employee response lots of times with clients going forward, can't you? So how should clients deal with that type of response?
They've got to deal with it carefully and patiently, and they've got to get the information relating to that particular employee and their family situation, because each of these individual cases is going to depend on its individual circumstances at home, because they're all going to be different. Obviously, the situation at work can be regulated to a large extent. That's what Kamal was talking about, the risk assessment, the publication of that, the explanation to employees as to why it's safe to return to work under the system that the employer has set up for that purpose. But ultimately, if an employee feels that they've got a reasonable belief that if they return to work, they are in danger, or they're in danger of becoming infected and then infecting a family member, they may be so important then they're not coming back. And then you're going to end up with either constructive dismissal claim in the tribunal, or if the employer takes the lead, a dismissal. It's going to be about whether the instruction to come back to work was reasonable. So it's an objective test. If it's a health and safety dismissal we're talking about, and that can work for resignation as well, by the way, you can resign on those health and safety grounds if you have a reasonable belief that you are in imminent danger by staying at or attending work. And we're going to have a lot of cases like that, with tribunals having to assess the reasonableness of those beliefs. Answer the question if you can, Michael. Well, I wouldn't if I was the employer. I'd be desperate to try and agree a return to work, or to find out exactly why it wasn't possible, and to try to accommodate the employee as far as I could.
Thank you, Michael. So yet more discussions, but this time discussions with patients, I guess you're saying, and keep even more careful notes, because almost inevitably it could end up in tribunal in one shape or another.
Yep.
Okay, so changing the emphasis now onto health and safety, although still with an employee perspective on it. So Michael, I may ask you to come in. A question from Andrew Wadland at Parkwood Leisure. Thank you for your question, Andrew. What guidance are there for dealing with employees who feel that there isn't adequate protective measures in place when they've been asked to return to work? And how is that best dealt with in terms of, again, meetings, discussions, notes, etc.?
Well, I think the first thing to say is that if you're inviting any of your employees to come back to work when they've been in lockdown for some while, you're going to be producing widespread publications. Kamal was saying about risk assessments, that's the start. But then there's got to be something much more positive than that, much more engaging with the employees, explaining why the employer is taking all reasonable steps to make sure that the workplace is safe before they're invited back to work. And so there's a lot of PR that needs to be done in that situation. Always, I mean, this is a slightly different situation, because often when I'm advising employers, in the past, in a non-COVID-19 situation, my employer clients are convinced that the employees are not being straight with them, that they're just trying to evade capture by not wanting to come to work or come to meetings. And so a lot of what I do is trying to paint the employee into a corner to try and make them engage with the employer. In this case, the employer should be laying it on with a trowel as far as publicising why their workplace is going to be okay, because they've taken all necessary steps to make it as safe as they can. I don't think there's any better guidance than that. I think what I'm not going to say is, oh, I'd contact each individual employee separately to give them individual reassurance. You can't do that, except in the smallest of employers. You've got to try to deal with the mass of employees in that collective sort of way. And then where people have individual points, there's no substitute for just engaging with them. Find out what their problem is. Is it in their head? Is it at home? Is there a family member? Why are they worried? Because eventually, if the employer is going to make a decision about things, they've got to have a pretty good idea as to whether their employee is worried in a reasonable way.
Thank you, Michael. So taking that question a stage further, would the tribunal be looking at what the nature of the family member would be and the issues involved, or will it just be no, the employee's position is generally reasonable? How will they tackle that on a calendar or a spectrum or a perspective chart?
Well, if I just deal with the easier situation of an actual dismissal, so an employer has said to an employee, you must come back, and the employee won't come back, and eventually they're dismissed, either for misconduct or some other reason, but they're dismissed because they won't come to work. In that situation, the tribunal is assessing what was the reason for dismissing, and the reason for dismissing was that the employee wouldn't come into work. And then it's a question of whether the employer acted reasonably in treating that as the reason to dismiss. And that's where a consideration of exactly why the employee said no would come into play, as it would in any other sort of unfair dismissal conduct case. If it's a resignation and it's a constructive dismissal, the tribunal would be assessing whether the conduct of the employer in insisting on the employee coming back to work amounted to a fundamental breach of contract. So undermine the whole relationship, and that would be the test. So those are familiar tests in the tribunal. So anyone who's looking in, who's had a tribunal case of those kinds, they'll know what the tests are there. The one I'm interested in a way, is the health and safety related dismissal in the Employment Rights Act, where the reasonableness of the employee in deciding that it wasn't safe for them to come back to work, tribunals won't have decided those things very often. And that's going to be interesting and difficult. It's still only an objective test. Was the employee reasonable in their belief? So it's familiar in that sense, but the tribunals won't have seen many cases of this kind.
Thank you, Michael. That's very helpful. I know we're getting lots of questions like that from clients, and I guess it's back to that advice, which is be patient, have those discussions, keep notes, and if in doubt, take advice. So thank you for that, Michael. Kamal, anything that you would want to add from a health and safety perspective on that particular question?
Yeah, so from purely from a regulatory point of view, say for example, if I were the regulator going into a business, the first question that I'd be asking of a business is, can you demonstrate to me as a regulator, have you taken reasonably practicable measures to ensure the health and safety of your employees and non-employees? And it goes back to ensuring that you have, in the first instance, engaged with employees as far as you can. And of course, there is a balancing act, as Michael very rightly said. You can't go and ask every single person what their opinion is, and indeed you can't go back further and ask what the family's opinion is of a certain situation at work. But you have to take it in large, and it comes back to this balancing act that I mentioned earlier, whereby on one hand you've got the risk, and on the other hand you've got the resource to mitigate that risk, and it's finding the balance between the two, which will hopefully give guidance and an answer to deal with those sorts of issues. Again, I'd come back to what I mentioned earlier in terms of amplifying the things that have worked really well for a business. So if it has been to work remotely or to stagger shift patterns, for example, let's use that as our evidence to go back to employees or people who have got real concerns about returning to the workplace and how they could deal with working in a safe manner, but use that as our business evidence, our corporate evidence, to allay any concerns and fears that people may rightly have when they come back into the workplace.
Thank you, Kamal. I think that's a useful supplement to Michael's comment about the practical steps you should be taking alongside those discussions. That's really helpful. So evolving the question to another level, thank you for the question from one of our attendees this morning. I don't know who it is, and they've asked it anonymously. Can I insist upon wearing a face mask without giving my employer opportunity to punish me indirectly? And the questioner has got in mind the case that we all remember, the necklace with the religious cross on it, and the employer and employee falling out over it. Michael, and then to Kamal, thoughts on employees demanding to wear a face mask?
Conscious of the time, so I'll be very brief, but this is a terrific question. I would be astonished at the moment, in the current context, if an employer started thinking of disciplining an employee who wanted to wear a face mask. But there are face masks and face masks, and exactly what sort you wear and in what circumstances you wear it, and for how long over the next few months, that context is going to determine whether you are acting reasonably as an employee in not obeying your employer's instruction to remove the mask. At the moment, I don't see that happening at all. It would be bonkers for an employer to say to an employee, you can't wear a mask. I go down to the supermarket and one of the people on the checkout's got a mask on, just a cloth one, but it's got some sort of Halloween motif on it. And I don't like that. It's scary. And then we drift on to things like dress codes. Is there going to be interest in or issues about dress codes, just as with the religious symbol or with tattoos? It's going to be like that. I hadn't thought of that until that question came in. Thank you very much.
Thank you, Michael. I can still see some employers, though, nevertheless having that discussion with their employees, despite your words of wisdom. So thank you for that. Kamal, anything that you would want to add from a health and safety perspective?
Yeah, the only thing I would add to that is if there are specific reasons for an employer or an operative not to wear a face mask, and that's the only reason I can think of. So say, for example, in the food and beverage industry, there are certain measures you have to take into account when you're working with food preparation, for example, but that is very, very specific. So, and again, I'll echo Michael's comments in the sense of it'll be a brave business that turns around and says, actually, we don't want you to be wearing a face mask because we've got no other reason than to say that expert evidence suggests you shouldn't. And I just, hopefully we'll be in a situation where we don't see that. And like I say, we think it's going to be a brave business that does take that view. But I'll just reiterate that different people have different appetites towards risk. And I mentioned earlier, healthcare workers working in retail, if you're working as a home delivery driver, you'll have a different exposure to risk. So we really need to be considering all of that in a round for when the employer makes that request on wearing a face mask. What are you business going to do about it? And when the business turns around and says, well, actually, I don't see an issue with you wearing a face mask, given your role. If you feel better wearing it, again, coming back to fact versus perception, if you feel better wearing it, please go ahead and do so. So that's where I hope we'll see this go.
Great, thank you, Kamal. Two quick questions to finish off. Conscious that time is fast closing in on us. The question from Clive Seabrook. Thank you for your question, Clive. Where does the burden of proof lie as to where an employee may or may not have contracted coronavirus? Michael, over to you.
Well, I suppose I have to think about the context, don't I? I'm going to get out of that question in a lawyer's kind of way by saying that, in line with one of my previous answers, that if you're in an unfair dismissal context, the employer has to show what their reason to dismiss was, and the burden is on them to prove that they were reasonable in acting on that reason, relying on that reason. So I suppose if there was a question mark over whether someone did in fact have coronavirus, the employer would have to show that if they didn't believe it, that they had reasonable grounds for not believing it. So in that context, it would be like that. I hadn't worked through all the other ways in which an argument about whether someone was sick or not would come into play. You often get sick pay disputes if the employer doesn't think that someone's sick, and what would you do? You'd get some sort of doctor's certificate or a diagnosis in order to get your sick pay if there was a dispute. But I think the burden, the exact way in which one would have to prove it, would vary depending on the context in which you're having the punch up, to put it bluntly.
Thank you, Michael. Kamal, anything from you in final thoughts on that?
Yeah. Yeah, thanks, Robert. I guess that question may derive from the comment I made about certain instances being read or reportable, and really the only context I can think of is in those two situations that I mentioned earlier, whether it's a dangerous occurrence, if, say, for example, a vial of substance containing the virus was dropped on a floor in a laboratory situation, then that I could see could lead to an unintended incident that leads to an exposure at work. So then you'd have, quite clearly, you'd have evidence of exposure in that workplace, which then the burden of proof then lies with the employer to make all the reporting available to the health and safety executive. And with regards to a case of disease, again, I mentioned that if an employee is diagnosed with having COVID-19 and there's evidence that it was caused by exposure at work, again, I can only see that being in very specific circumstances in a laboratory sense, for example, or where the virus is cultivated for a specific research purpose. So again, in those sort of situations, it'll be the business that will have the obligation to report, and then for the regulator to then undertake an investigation to see if there is any wrongdoing on either party.
Thanks, Kamal. Thank you, Michael. And one last question, and a question for Dan, and it's a question I couldn't resist asking. I think we all hoped that, along with Brexit, that GDPR had gone away with this COVID-19 pandemic, but unfortunately, just as Brexit starts to pop back up again and show its rear its ugly head, so do GDPR questions. So a question for Dan. Dan, where do we stand at the moment with GDPR and COVID-19? And do any of the regulations step back as a result of the situation we'll find ourselves in?
Yeah, so I think the interesting thing is with this is obviously, given what's going on with COVID-19 and obviously what Michael and Kamal have spoken about with health and safety and obviously employees generally, I think from what I've seen is that GDPR can easily slip through the net. So I think it's one of awareness that obviously employers should definitely be sort of wary of in terms of, you know, what information they should be collecting from employees in terms of their health data. So there's probably three main points to this to be aware of. And the first one is data collection. So obviously with the current situation, the organisations may be tempted to collect as much information as possible relating to an employee. So for example, whether those employees have self-isolated, information on the body temperatures of employees on site and also visitors to site, and also device location data. So all of this information is obviously considered personal data, and because most of it does pertain to an individual's health, that will also fall into the subcategory of special categories of personal data. Now, we know that GDPR requires organisations only to collect as much personal data as is strictly necessary for the purpose being pursued. So data minimisation is definitely the key. So if you are obtaining that data from individuals, or you're asking specific questions about whether they've isolated, who else in that household may have had coronavirus or are self-isolating as well, it should very much be recorded on a kind of yes/no basis. So definitely a few amounts of information on the topic than you can is definitely the better way forward. The second point then is the sort of legal basis for that processing. So how can you hold and store that data and use it effectively? So again, we know that organisations have to have this legal basis for processing data. And in this current situation, you could probably comfortably rely on legitimate interests, contractual necessity, so to ensure the health, safety and well-being of employees, and obviously legal obligation in terms of all the new coronavirus laws which we now have in place and sort of the government restrictions. So in sort of addition to identifying that lawful basis, if you are processing these special categories of personal data, obviously it must fall within one of the special conditions. And obviously if you are collecting data for public health reasons, which a lot of organisations will be, therefore you're acting on the advice of public medical advisors. So this would probably allow you to justify processing of those special categories of data relating to coronavirus. But it's also worth considering your sort of legal basis for that. And I think the third point as well is reviewing your current policies and updating any kind of remote working policies that you have in place. So we know that organisations are going to be collecting a new kind of categories of personal data, obviously the special categories that we've mentioned about for employees, and it will be used for new purposes. So it'll be likely to update your, necessary to update your privacy notices to reflect that change in how you collect data from employees. And it's probably as good a time as any to review, like I say, your remote working policies and remind employees of their kind of obligations under those policies. And I think also another one which organisations may or may not be doing is data protection impact assessments. So have these been done? The GDPR does require one of these impact assessments to be done, if any processing of data is likely to result in a higher risk to individuals, arguably with health data it will be. So just be aware of, can you carry out some impact assessment to actually see the impact on your business in terms of collecting this new data. A point on the ICO as well. So they've stated recently that obviously the current situation with COVID-19, it will look to adopt a more reasonable, pragmatic approach to enforcing any data protection obligations. So although ICO may seem to exert some leniency in this regard, as we know from the recent EasyJet case just yesterday, they're still hot on the trails of businesses not complying with GDPR generally. So I wouldn't rest on your laurels in terms of COVID-19 for this personal data collection. But what I would do is just be conscious of how you are processing and storing that data. If you are asking for more data than you probably need, and obviously review your internal policies probably straight away just to see if you need to change these given the current situation.
Thank you, Dan. That's a useful summary of the updated position on GDPR. So you've heard it from Dan, I'm afraid. GDPR doesn't go away despite COVID-19. We've all got the joys of that to continue to deal with, I'm afraid. And I'm sure once we've finished doing COVID-19 webinars, we will be giving you very soon a GDPR webinar, followed no doubt by a Brexit webinar as well, as that starts to rack up towards the end of the year. So thank you very much, ladies and gentlemen. That concludes our webinar this morning. Thank you to our speakers. Thank you for you as attendees. We will be sending out to you in the course of the next few days a copy of this webinar and also replies to the various questions that have been asked. If you've got any further questions or you want to pick up any points with any of our speakers, you can find their details on our website, www.hcrlaw.com, and you'll have details there of both their email and direct lines and mobiles. So please don't hesitate to pick up with any of them personally. One final thing then of note, our next COVID-19 webinar will be early next month, and we'll be looking further to the future in terms of everything you need to know about getting in work, back to work, carrying on with work, and again giving you an overview from an employment and commercial and other perspectives for you and your business. If there are any particular topics you'd like us to cover in that webinar, then do please let us know. Always happy to look at any suggestions from you. But other than that, thank you very much for your time today, and hope you enjoy the rest of your day. Thank you very much.